I'm here to introduce JP Ellis, who is from Ethical, who has been a great supporter of women's health and the Better Ops program. And this is where we got to know each other and became friends. JP is an admitted attorney with a BCom and LLB degrees with the right of appearance in the High Court of South Africa. He is the head of legal for Ethical and is responsible, number one, for providing general policy advice and management, two, assisting in the underwriting of applications, educating with panel attorneys in the management of claims, which we appreciate, providing advice and opinions on regulatory aspects pertaining to the Short-Term Insurance Act, Financial Services Board Act, and the Financial Advisory and Intermediary Services Act. He's also responsible as one of his tasks of drafting commercial documentation in compliance with relevant statutory works, coordinating as well Constantia's medical law reform initiatives within various industry stakeholders. And he puts it as number 7, but providing medical, legal and related advice to healthcare professionals. And this is the one that I abuse him with often with questions and queries in his extremely busy schedule. And despite having all of those tasks in a very busy schedule, he still has managed to be a part of our Mowbray Maternity Hospital. For those of you who don't know, it's one of our biggest maternity hospitals in South Africa, here in Cape Town. And he has been selected by the minister to be a board member of our health facilities board, where his legal expertise does help to assist. So it's my great pleasure to have JP chat to us. And it is a topic where it's a long topic, and it's one of those topics where I phoned him up and said, please, can you help with this? So I'm sorry I gave you a long topic, but thank you so much for giving us clarity around it. Thank you, JP.
Thanks, Malika. As always, thank you to the event organizers, especially Royal House, James Shaw, Alison Shaw, and the SAMS Council for the invitation. It's always a pleasure to avail myself for these important seminars. Hopefully you can see my screen okay?
We can see your screen perfectly, thanks, and we can hear you well.
As Malika said, it's quite a loaded topic, and I propose dealing with it in 2 separate aspects. No doubt they are related topics and they overlap in a variety of aspects. Given the time constraint, I will confine myself to highlight the applicable ethical framework and to provide some practical takeaways. So just a couple of disclaimers, as you would expect from a lawyer. I need to set out that disclaimer that this is purely a guidance and it's not intended to be specific legal advice. Always keep in mind that it's impossible to develop a complete set of specific ethical prescriptions to every conceivable real-life situation. Therefore, booklet 1 of the HPCSA guidelines encourages healthcare practitioners to adopt what we call clinical reasoning. And maybe I should add another disclaimer. I've got small minor kids that have just finished swimming, so although I've put around signs outside, they don't read, so apologies if there's some kids screaming. So misinformation is, essentially either some sort of miscommunication or innocent misrepresentation. And I think that's in itself a very easy thing to deal with. But for me, the more important one, or the one that's more sort of juicy, is the issue of fringe science, which refers to ideas whose attributes include being highly speculative or relying on premises that are flawed. In other words, from a lay perspective, it's what we call mumbo jumbo. So I'm going to sort of focus more on that because I think that's probably the much more interesting aspect. In the medical context, we are more familiar with the term quack medicine, which is derived from the Dutch word quacksalver, and that's synonymous with the term charlatan. So quack medicine has existed throughout history. For example, human fat from the recently deceased was harvested and used to treat aching joints and rabies. Drilling of holes into human skulls was thought to be useful in releasing evil spirits. At some stage, you might have come across the term blowing smoke up your rectum. It was actually a practice in England using tobacco smoke enemas as a means of saving drowning victims in the Thames River. Opium was a respectable go-to reliever sold over the counter for respiratory ailments and also given to children. Egyptian mummies were stolen and sold overseas for eating. Apparently, they were used to treat ringworms and the plague. Snake oil was thought to be a liniment that could cure everything and contained beef fat, turpentine, but no snake oil. Although some of these questionable practices were best practices in their time, we've come a long way in the practice of modern medicine. We know so much more about the human body than what we did before. Surgeons wash their hands today, whereas before that wasn't always the case. The question is, why is there still a huge industry of unproven treatment methods, misinformation, or fringe science that exists today? Often useless and sometimes dangerous products make their way to the public, including your patients. And I'll pause here and just mention that, as you can see, not too much of a surprise, but I suffer from mild pattern baldness. So I'm familiar with these products that get sold to you and offered to you as cures for all sorts of things, even male pattern baldness. So recently, even in today's time, we see things like COVID-19 treatments being pushed that may not be proven. The reality is that we don't have cures for everything and we don't know everything about the human body. So that leaves a lot of room for fringe science and misinformation. You can't possibly be experts in all your patients' diseases and potential treatments. And you need the assistance of other specialists and skilled healthcare practitioners. So there are a number of ethical principles that I'm going to just touch base on that will probably be applicable or that you might be familiar with. Regardless of the situation, you should at all times act in the best interest of your patients, regardless of their clinical needs. Appreciate the circumstances of your patient and recognize their condition of vulnerability. When patients are confronted with life-threatening circumstances, they typically look for hope in the unconventional. Don't allow your personal beliefs to prejudice their healthcare. Otherwise, inform them of their right to see another healthcare practitioner. Overservicing is a prohibited act and a very contentious issue. According to Rule 7 of the Ethical Guidelines, it is an extremely wide definition, but it includes any treatment or care which is medically and clinically not indicated, unnecessary or inappropriate under the circumstances, or not in accordance with recognized treatment protocols and procedures. Thus, unconventional treatment may fall within the ambit of overservicing. The HPCSA ethical guidelines further prescribe that you shall not provide a service or perform procedures that are neither indicated nor scientific or have been shown to be ineffective, harmful, or inappropriate through evidence-based review. You should act quickly to protect patients from risks and report violations where you have good reason or persuasive reason to believe that their rights are being violated. You should maintain and improve the standard of your performance, but at the same time, you must acknowledge the limits of your professional knowledge and competence. So don't pretend to know everything. Healthcare practitioners shall only use an apparatus or health technology which proves upon investigation to be capable of fulfilling the claims made in regard to it. The healthcare professional shall perform, except in an emergency situation, only a professional act for which he or she is adequately educated, trained, and sufficiently experienced under the appropriate circumstances. And then just also to highlight, you'll see Rule 8 of Booklet 16, which is a new booklet that was recently published on the guidelines for social media. And since we live in a digital world, we must acknowledge that interacting with patients on social media can make you privy to personal patient information that is not disclosed in the usual healthcare setting, and that may result in ethical dilemmas. So just the takeaways in summary: always show compassion for the vulnerable patient and appreciate the situation that they find themselves in. Act in the best interest of your patient and do not allow your personal beliefs to affect your treatment. Rely on your clinical expertise and not on unreliable information. When in doubt, use ethical reasoning advocated in Booklet 1. Touching on the second topic about how not to malign your colleagues, I propose dealing with it as a case study. So we've got a situation where a junior doctor is alarmed by the behavior of a more senior colleague who uses out-of-date techniques that prolong operations and result in greater post-operative pain and longer recovery time. The senior colleague frequently makes crude jokes about patients, and the junior doctor is reluctant to criticize his colleague personally or to report his behavior. So first, So I'm going to deal with it in sort of 4 stages. The first stage is to let's consider how the healthcare practitioner should behave towards one another. As members of the medical profession, healthcare practitioners have traditionally been expected to treat each other more as family members, and the World Medical Association Declaration of Geneva includes the pledge, "My colleagues will be my sisters and brothers." Ethical rules in Booklet 1 require healthcare practitioners to work with and respect their colleagues in the pursuit of the best healthcare possible for all patients, to not discriminate against one another, to refrain from speaking ill of colleagues, and to not make a patient doubt the knowledge or skills of colleagues by making comments about them that cannot be justified. And the next point is very important. Rule 12 of Booklet 2, and just as a side note, Booklet 2 is the only ethical guideline or booklet that has been published in the Government Gazette. So you'll see an extract on the right-hand side. So it has the status of regulation. So importantly, Rule 12 says that no healthcare practitioner shall cast aspersions on the probity, professional reputation, or skill of your colleague. So the second stage we're going to look at is what justifies reporting of unethical behavior of colleagues. So there's a general ethical obligation on you to report incompetence, impairment, or misconduct of colleagues. The World Medical Association International Code of Medical Ethics states a physician shall report to the appropriate authorities those physicians who practice unethically or incompetently or more engaged in fraud or deception. Ethical Rule 10 of Booklet 1 provides that healthcare practitioners should report colleagues in circumstances where they have good reason or persuasive reason to believe that the rights of patients are being violated and or where the conduct of the colleague is unethical. Those people who report such misconduct must be protected from victimization or intimidation. Now, obviously, it's easier said than done. The application of this principle is not always easy. On the one hand, you have a healthcare practitioner that may be tempted to attack the reputation of a colleague for unjustified motives, such as professional jealousy or in retaliation for an insult by a colleague. On the other hand, a healthcare practitioner may be reluctant to report a colleague's misbehavior because of friendship or sympathy. The consequences of such reporting can be detrimental to the person who reports, including hostility on the part of the implicated colleague and possibly other colleagues as well. Now, despite these drawbacks, it's important to recognize that reporting wrongdoing is important because as a professional duty of all healthcare practitioners, you not only have that duty or you're not only responsible for maintaining the good reputation of your profession, but often you're the only one who recognizes incompetence, impairment, or misconduct. So, however, reporting colleagues to the disciplinary authority should normally be a measure of last resort after other alternatives have been tried and found wanting. And usually we advocate things like mediation or direct engagement. And then if that doesn't work, obviously going to other colleagues or even if there is an ethical committee, then you can approach them. And the last 2 stages is to look at the ethical principles relating to cooperation with colleagues and resolving conflicts. So in terms of cooperation, medicine is at the same time a highly individualistic and a highly cooperative profession. On the one hand, a healthcare practitioner is quite possessive over their patients. On the other hand, because medicine is complex and specialized, they require close cooperation amongst colleagues with different but complementary knowledge and skills. This tension between individualism and cooperation has been a recurring theme in medical ethics. According to the World Medical Association Declaration on the Rights of the Patient, the physician has an obligation to cooperate in the coordination of medically indicated care with other healthcare practitioners treating the patient. There is certainly a move from the traditional approach of absolute authority to greater participation in medical decision-making. Healthcare practitioners will have to be able to justify their recommendations to others and persuade them to accept their recommendations. Rule 8 of Booklet 16, which I mentioned earlier, prescribes that healthcare practitioners must not post their opinions on the probity, skill, or professional reputation of their colleagues on social media. If your colleague makes derogatory or inappropriate comments on social media, practitioners are urged to bring it to their attention discreetly and to not engage or respond publicly on the social media platform. Dealing with resolving conflicts about patient care, disagreements among healthcare practitioners about care and treatment, or disagreements between healthcare practitioners and administrators with regard to the allocation of resources. Those are by far the main two features in these type of issues about patient care. Both types of conflicts are ethical in nature, and their resolution can benefit from the advice of a clinical ethics committee or an ethics consultant where those resources are available. But the main guidelines to be used for resolving conflicts are fourfold. Firstly, the conflict should be resolved as informally as possible. Two, the opinions of all those directly involved should be given respectful consideration. Three, the informed choice of the patient must be given primary consideration, or in the case of a substitute decision maker. Four, if the dispute is about the options that the patient should be offered, a broader rather than a narrower range of options are usually preferable. And if the healthcare practitioner cannot support the decision that prevails as a matter of professional judgment or personal morality, they should be allowed to withdraw from participation in carrying out that decision, after ensuring that the patient is not at risk of harm or abandonment. As with patients, there are obviously legitimate grounds for refusing to enter or for terminating a relationship with another healthcare practitioner. Some takeaways. So legitimate critique of a professional activity is appropriate so long as the professionalism is maintained. All doctors have a duty to raise concerns where they believe that patient safety or care is being compromised. You have a duty to put patients' interests first and to act to protect them, which overrides any professional or personal loyalties. The law provides general legal protection against victimization for individuals who reveal information to raise genuine concerns and expose malpractice in the workplace. And lastly, you do not need to wait for proof. You will be able to justify raising your concerns if you do so honestly on the basis of a reasonable belief and through appropriate channels, even if you are mistaken. And then just coming back lastly to the case study, in this situation, the junior doctor would be right to be alarmed at the behavior of the senior colleague. Not only is he endangering the health of the patient, but he's also being disrespectful to both his colleagues and the patient. The junior doctor has an ethical duty to not ignore this behavior, but to do something about it. As a first step, you should not indicate any support for the offensive behavior. So in this case, if there's laughing or crude jokes being made, do not engage in that. And if he thinks that discussing the matter with his colleague might be effective, he should go ahead with this and try to resolve it in that way. Otherwise, he may have to go directly to the higher authorities in the hospital. And again, lastly, as a matter of last resort, approach the regulatory body, namely the HPCSA, and ask them to investigate. So sorry if I went a few minutes over the topic. Like I said, it was a...
We'll forgive you. JP, thank you so much. I know that we did not do your time justice because there is lots more, and I know you've summarized it beautifully, and thank you for always accepting the mandate. I think I agree with you, the kind of, it's very difficult for junior doctors, and being part of the South African Medical Association sometimes, and a lot of junior doctors would talk about what they believe their intimidation or abuse would be like, and how they feel that, and I'm glad that you highlighted the whole whistleblower role and how essential sometimes it is, and that we should as professionals create an environment with each other where we can resolve conflict, and also, as you say, an environment where you don't accept certain comments or things that are said that are inappropriate, but that also I was listening to you say, you know, don't agree with it. And I was wondering, ek stil bly so ook maar antwoord. So, you know, well done to those who actually have the courage to speak up in those situations. So, JP, there's one question here for you, and it's from Attila, and here she says, I once read an article in the Reader's Digest a while back where it had given short summaries about funny incidences in medical practices. Obviously, wait, they just hopped away. Obviously not mentioning the country or the hospital where it occurred. In this age of social media where you would know who potentially was posting things, and in relating an interesting story without names or locations, say in a WhatsApp group with friends, is it wrong? Is it a crime? Is it punishable? Because a lot of people would often say to me, geez, Marika, you should write a book. And I keep thinking that the HPCSA will definitely report me, because sometimes I can't change the names of the crazy or the not so crazy. The people will recognize themselves in my story. So what's your opinion about that, JP?
I think as a general rule, it's probably better to refrain from participating in those type of conversations. But obviously, when it's necessary or it's for educational purposes, as long as you can anonymize in such a way that you cannot reveal the identity, or it's not plainly obvious who that person is, or you can obviously change the specific situation or references, but then it should be fine. Then there shouldn't be any issues from an ethical perspective.
Yeah, JP, and then you know how difficult it is to try and appropriately cover us where obstetric indemnity insurance is concerned. And somebody is asking that at a certain hospital group, and there are a few around the country that sometimes allows non-specialists to do obstetric deliveries, and this often may lead to frequent complications. So I think those who are there may be worried about that. What is the recourse of a specialist in a setting like that if you're at an institute where a non-specialist is allowed to do obstetric deliveries?
Yeah, look, as I mentioned, I mean, there are ethical obligations on you where you feel that it's out of the realm of the competence of that person, then you should raise it formally. Naturally, it will be better to raise it formally with that particular hospital, with its management or the ethics committee. But, because, yeah, I mean, those things are quite tricky. I mean,
sorry, JP, to interrupt you, but I want, you and I have had this conversation where when we try and deal with impaired colleagues, the HPCSA has their guidelines on what to do around that. But one of the things that's always struck me when we deal with impaired colleagues, whether surgically, mentally, substance abuse, any other issues, was that one of the things that I really took a take-home message from one of your colleagues who once said, please be aware that if you are aware of dangerous behavior and you are not reporting it, you could potentially be held as liable because of stilblyk being an antwoord. So, what would your comment be around that?
Yeah,
I mean, often,
yeah, no, it's 100% true. I mean, often in the context of litigation, you'll find that hospitals as well as specialists are co-defendants, and there's obviously this tension between them because it's a question of, well, whose responsibility was it at certain stages. But more so, even if you are a practitioner who provides, in your view, your risk profile is relatively low, or you're quite conscientious and risk averse, always keep in mind that there is a specific element that relates to the environment where you practice. So you can be the best practitioner ever, but if your environment is not conducive for that, unfortunately, you will find yourself in those situations where you get drawn in as a co-defendant or being roped into all sorts of difficult ethical issues.